India has one of the most beautifully written constitutions in the world. It promises justice, liberty, equality, and fraternity to every single citizen. And yet, for most people who walk into a courtroom in this country, the experience is the opposite. My guest here today has spent his entire life standing in that gap between what the Constitution promises and what the system delivers. Hello, everyone. Welcome to LAOT podcast. My guest today is Professor Upendra Baxi, Emeritus Professor of Law at the Universities of Warwick and Delhi, former Vice-Chancellor of Delhi University, and widely regarded as the most consequential legal scholar India has ever produced. Born in Rajkot in 1938, he studied in Bombay, Berkeley, and Sydney before returning to India in 1973. And what he built here has changed the country. He wrote an open letter that reformed India's rape law. He started the first 5 year LLB degree in India, and he also invented what he calls as social action litigation, the practice of bringing cases to Supreme Court on behalf of those who cannot reach it themselves, prisoners, bonded laborers, and the destitute. He was also on the front lines of Bhopal. His writings have been cited by the Indian High Courts, the Supreme Court, and the International Court of Justice. Professor Bakshi, thank you for being here.
Thank you indeed, Sannidhi. You have done a marvelous introduction. You could have been even briefer because I don't deserve all the accolades. I did what I have to do as a learner in law, a student in law. And it's a funny thing. The more you try to change things, the more they remain the same. So, in a sense, at the end of the day, one doesn't feel very great about it. But anyway, it's very nice to be with you, and hello to all your colleagues. And you're doing a wonderful service to legal information, knowledge, and reflection by your blog and by other activities. So I'm very proud to know you and greet you all today.
You're very kind, sir. Thank you so much for saying such great words about LAOT. I want to start at the very beginning. You grew up in Rajkot, you could have built a life in Berkeley, Sydney, but you chose to come back to India. So, when you came back to India in the year of 1973, it was also just 2 years before the emergency, and Berkeley was also in the middle of the American civil movements. And it was also the year that the landmark Keshwanand Bharti case had happened in India. So, when you came back, what did you find in India, and what was your motivation to come back, sir?
Yeah. Thank you very much. I'm sorry for all the interruptions and delay in talking with you. It's a great pleasure to be with law and other things. And my mind goes back on this occasion because I think you used the word eminent or something. And Krishna Iyer, my beloved friend, Judge Justice Krishna Iyer, he allowed me to call him as Krishna, and I now call him beloved Krishna. And beloved Krishna was once saying to, when I became Vice-Chancellor of South Gujarat University, and before I beheaded it, afterwards I beheaded Delhi University also, he wrote me a letter of congratulations. But I was surprised and I read it. It was a short letter. Uh, it was the end. I knew that Krishna had always this twist in his tongue. And he said, congratulations, all that very nice thing. And then he said, but remember Bernard Shaw who said, the more eminent a person is, the more he or she has done to be ashamed of. So I thank you very much for calling this person eminent. But I remember Krishna Iyer and Bernard Shaw on this occasion. Anyway, thank you for inviting me. You were very many distinguished people before me. But conversation. Uh, but anyway, that's your privilege. I wouldn't share. Now, I've a lot. I was I was never a student in Sydney. I had the privilege of teaching there, and I don't use the word teaching either because it's phonetically very similar to cheating. And I used, of course, I don't use the word education, higher education also, because it conveys a caste system. There's something lower and there's higher. I think if you have to go by the higher and lower, then elementary school education is the highest. And then it decreasing scale, it becomes less so. The foundation is we all go to elementary schools and learn CAT, CAT, BAT, BET, and then become scholars of sorts. So anyway, that's a part. That's a general thing. I victimized some students in Sydney University by I don't use the word teaching. Co-learning is a better word. We learn from the teacher learns from the taught more than the taught learns from the teacher. It's my experience. Everything I have done in my life is through a question in the classroom or a comment in an exam paper. I've unlearned a lot of law from my students and learned a lot of it from my students. So I never use the word teaching, but it implies a social distance between teacher and the taught. And I don't like hierarchies of any kind. I know they're necessary evil, but even then we don't make more evil out of that. So I was a co-learner in Sydney. And then I came to Delhi University. I was invited, not appointed. So I had thought somebody was playing a joke on me, so I put the paper away. Another letter came to the registrar saying, we had written to you, invite you as a professor. And then I showed to Julius Stone, who was my colleague. I was privileged to have him as my colleague at Sydney University. And I said to Jules, I said, have a look at this. He said, son, this is very good. You are being invited to a chair. And you should immediately say yes. What did you do with the first letter? I said, I don't know where I put it. So you can't be so careless with such invitations. A university inviting a person. Oh, I was then very young. I was 30, 31. And I was, in fact, coerced to accept the invitation by Julius Stone, which I happily did. So I came to India without knowing where Delhi University was, where it was located, having no contact with Delhi University, but I'm a Bombay boy. I studied my law in Bombay. Yeah. And I was for long years a correspondent in Free Press Journal of India, Times of India, somewhere, which every Friday there appeared something called campus jottings. I edited and wrote them. So I began as a law student, but also as a journalist together. And I think both the professions go together. And they still go together very much in some senior lawyers that you nowadays see in India. But I don't say I started the trend, but there's a trend that because with journalists who have been called, what are they called? Journalists are called the first draft persons of history. That's a very high tribute. So lawyers, I think, law persons are also first draft persons of history. Both are so-called learned professions. And what is rumor and what is news, they both specialize in the distinction and thrive on not telling you what this distinction is. So it's very interesting. Anyway, that's by the way. Thank you for waiting, and it's been a sheer pleasure to be with you at long, long last, via all the tricks of Riverside. Tell me, what can I do for you?
Yes, sir. So, thank you for giving us the context, sir, of your journey. So, you've described yourself as someone who tries to combine the law co-learning, like you said, with human rights activism because you've been involved in the open letter for the Mathura rape case.
Echo in effect for a second. Um, Telephone is all right now. I do it later. It's just clear out and scan out your files. My God, this telephone's combined to do some impossible things. Carry on. Now
Yes,
the
sir.
noise of
Can you hear me
so
now,
yeah,
sir? Yeah.
yeah. I'm very audible.
Yes, sir. So thank you first of all for giving us the context of your journey. So you've described yourself as someone who tries to combine teaching or, like you said, co-learning with a human rights activism because you were involved in the open letter for the Mathura rape case and the social action litigation that you started, and also you've been in front of the fight against the Bhopal gas tragedy. So, when did you realize that it is not just academic stuff, but it is also the on ground work, and the classroom was just not enough, you know?
Yeah, we need the responsibility for peaceful social change is indivisible and inalienable. The teaching or the medium for social change. Learning law is a medium for social change. In the constitutional direction, social change can be of many sorts. There can be regressive social change, there can be progressive social change. Everybody defines what a social transformation is for oneself. And nobody can contest it. If you're doing it for yourself, you believe this thing is transformative. Nowadays, people talk about transformative constitutionalism. God, if any, bless them. But all constitutions are by nature, in my view, transformative. So it adds nothing to the word constitution to precede it by transformative. Constitution change things, existing order of things. So it's a mystery to me why the word I myself edited a book called Transformative Constitutionalism to other people. Um, but I did it practically for fun because I questioned the concept of what is transformative in constitutions. And several South African colleagues agreed that there was nothing transformative about the constitution. In fact, some believe constitution is a means of subjection and repression. I myself had a long thought. I said, let us not be reductive. So I have four ideas about constitution. A constitution can be repressive, it can be changeful, it can promote development, and it can promote justice and rights. So there are four things: governance,
Yeah.
development, justice, and rights. Every constitution in the world, Sannidhi, every constitution in the world does attend to these four things.
Yes.
Whether they do it in a regressive way or progressive way is a matter of value judgment and context. But every constitution does these four things: G, D, R, D, right? And J, DDRJ.
Yeah.
Four ideas: constitution, governance, development, rights, and justice, whatever they are. So this is what essentially what constitutions do. Um, um, it's supposed to be the grammar of change or in detail, it's supposed to be many things. It's supposed to be laying down not just the framework of governance, but laying down parameters of social change. That's very important. How far you can go. And today the Supreme Court is considering some of the past decisions, like Sabrimala, or reviewing the old decision of Krishna Iyer on whether Bengal water supply case, something is industry or not. I don't know why they're doing it, but they're doing it. That's another matter. So essentially, it's important to legal education. I don't use the word legal education. I'm sorry, I'm a difficult person, but I don't mean to be difficult. I use the word, what is education to me? I ask myself, and I use the word LTTRSF. Learning, talking, thinking. LTT, researching, social formation. That's what it is. If one is not learning, thinking, the TT, thinking, and talking, not just talking. Learning, thinking, talking, researching, social formation. To my mind, is LTTT, RFSF is a better place than calling the word legal education. So anyway, it's just for starters. Now sorry, I'm not responding fully to your questions, query, but I'll be more precise I will try and find my notes if I can, but I will get into that. Yeah.
No, sir, you've actually really answered our question and put things into perspective of why this type of education needs to go beyond the classrooms, and there needs to be the human rights approach that you have taken to this. Sir, you've also, India right now has around 55 million pending cases, and Supreme Court alone has 93,000 cases within that. And your recent piece also talks about how the government itself contributes to a lot of pending litigation. And you've also called it an intergenerational justice, because you said uh, there is one generation which files the case, but the actual justice or the judgment only comes way after. So now, what is this? Is this a crisis without the solution? What is your opinion on this?
Oh, well, I had written a book a long time ago. One of the books was called The Crisis of Indian Legal System in 1982. I'm sorry if it was before you were born, but that's how things are. Um, in 1982, I said that if uh, I analyzed this situation of delays, and now it got described. I described delay as anything that you have to do normative labors on, takes time. So the question is how much time it should take, and therefore it's an empirical question and a moral question. Now I did some empirical study in order to write the chapter. I said delay is a useless word unless you know how much time ought the court should take to decide a matter. Without applying norms to facts, the court can't decide anything. The court applying norms to facts might say, these are not facts. Evidence Act says may presume, shall presume, all of Evidence Act says obstacle race for real truth to come out, as Justice Jerome Frank, a fact skeptic in America, said. Real facts never walk into a courtroom. It is what are called operative facts, admissible facts. So the law stands to set up a lot of roadblocks of what can come into it. Irrelevant facts don't come. There is some animal called cause of action. Not everything is a cause of action. Only some things are causes of action. You know that. So, in a sense, there is law has as a long time ago, Lord Cook of England said law has, and in these days of AI, it's very important to remember this. He was the first guy to talk about it in 17th century. Lord Cook said to King James the first, I have short memory about tyrants, but nevertheless I remember his name. King James I was 1600. He succeeded Queen Elizabeth the first. And the king himself wanted to decide certain disputes and adjudicated them. And Lord Cook, in a judgment, said to His Majesty that you have the greatest wisdom on the earth, next to God, and you can decide any dispute you like. But you cannot decide dispute inter partes. Only judges can. Because the law has, I quote, artificial reason of its own. That's what he said in 17th century. Right? Today we talk about AI. Artificial reason, exploring, making it more artificial. Let's put it that way. AI, artificial intelligence of law. So it is true in a sense that only certain facts that the law allows walk into courtroom. Not everything as it happened comes. Not the entire set of happenings. So when you talk about access to justice, it's different from access to law.
Okay.
Right? And out of the, if you look at the great work of Justice Krishna Iyer and Justice Bhagwati and Justice D. Desai and some others, you realize from social action litigation, which you mentioned, that translating people's suffering into rightlessness, absence of rights, righticide, killing of rights, and to put them in the language of rights, like the social action litigation, which is different from the so-called public interest litigation that I don't go into difference now. So the expansion of law, the development of law occurs only when people talk about relationship between law and justice, not just law itself.
Yeah.
But I'm widely straying from your question. Tell me again, what was your precise, what did you wish to know precisely? Sorry about that. I have a tendency of going around the subject and probably never answering the question.
No, sir, it was really interesting how you mentioned that there is a difference between accessing law and accessing justice. So could you
Yeah.
please elaborate on that?
Well, um, justice, again talking Krishna Iyer, in his, after he retired, he wrote a article, I think SSC or something, which is my favorite article, or a book, I think somebody wrote, said there are two kinds of judges.
Okay.
Those who are the quote unquote shopkeepers of law,
Okay.
as distinct from those who are legal missionaries. So
Okay.
there are two kinds of lawyers. Or largely one kind of lawyers who are shopkeepers of law. They occasionally deal with justice. So legal missionaries can be described in several ways. They can be described as proactive judges, active judges, judges who struggle to establish relationships with law and social change. For example, rights of women. The way in which gender justice has evolved helped the internal struggle of justices themselves. When we wrote the Mathura open letter, our concluding paragraph was that we do not seek, as law teachers, any review of the judgment. Because to ask a review of a judgment in a criminal case is not the function of a law teacher. In a criminal case, court should have the last word, not the court of public opinion. Crime and punishment are very demanding matters, and it should be left to judges. So when we did the open letter, now this was the first open letter in the world ever written. And I wrote a draft letter, and I found it very difficult to find any colleague to sign. First of all, they thought it contemptuous and libelious to write an open letter to the judge, to Supreme Court. Never was it done. And it was, I'm not going to it, history of it, but it was I could not eat, drink, or sleep for 8 days. I said, what do I do if a ranking justice again done? The judgment was that I went to complain about my brother who was missing for 8 days to a police station. They raped me. And I was a young tribal girl of 16 years, and the Supreme Court decides that since there were no marks of resistance on my body, no rape was committed. So I said in the draft letter that we do not seek a review. I want the Supreme Court to reflect on this. As law teachers, we don't seek for review. We mind our own business. We let lawyers do their own. We let the movement do their own. But injustice is our business, definitely, as law teachers. We don't point out, who will? Don't the management do it? A teacher of physics do it? Who will talk about justice? Teacher in chemistry, botany, astrophysics? Who will talk about justice if not law teachers and law students? Who else will talk? I wonder, a question is hanging in the air, but to me that letter answered the question. So the urge is, it's called hyperactivism, whatever it is called, the law teacher and the law student must be able to say what is manifestly unjust. And not to be able to say this is paralysis by thought. Too much theory, too much... when you don't look at the real anguish of the person who is denied fair play or minimum dignity, even residual dignity, where something that done against my consent or something that done to my body without my consent, where my dignity is taken away. And dignity cannot be given away. Dignity it's a duty to maintain your own dignity. It's not just a right, it's a responsibility. So anyway, my colleagues thought it was very difficult for me to do that, but first of all, it was an open letter. Secondly, it sought to establish connection between law and justice by raising questions about a criminal matter. Thirdly, it was interference in justice system. But we not really did it. I mean, we ultimately got Kritika Sarkar to sign it. We ultimately got very conservative, very good criminal lawyer, criminal law teacher, who later on wrote on a book on law of criminal procedure, Raghunath Kelkar. So with great difficulty, we got Raghunath Kelkar, Vasudha Raghunath, in Pune, 4 people to sign out the whole wide world. And we said it was good enough. And we did not merely write a letter. We worked for 5-6 years
Yeah.
to get the law reform, IPC reform. We appeared before the select committee ultimately. We lobbied legislators. And lobbying was just a word for Lautika and me. So I said, you speak Bangla and I speak Gujarati. We took MPs by language and went to South Block and North Block and lobbied. We of course spoke Hindi, so it helped, Hindustani. It helped. So it is a, now if you say this is not the job of the teacher, well, there's a correct view. If activism means not teaching well, not taking your classes, we never ever not take our classes. Of course, it became very difficult with the Agra home case. We actually went to start the social litigation. The courts function on their own time. They didn't expect teachers to litigate. They did accustomed lawyers litigating. When we took the Agra home case, regular writ petition, and we did some difficulty because sometimes they called us at 1 o'clock when we had a class, and they didn't hear the matter. So it was they passed over to some other day. The schedule was conflicted. But I must say that kind of activism would not have been possible but for the fact that the class, the students themselves, agreed to the inconvenience thus caused by the conflict in timetable. They're very good to us. I must say, I must acknowledge this, that they agreed classes to, at all hours, suddenly change. They could have protested, they could have gone to strike against us, they could have urged an action against us. Nowadays, for everything we ask for impeachment, right or wrong. But they didn't do it. So it was a joint effort in a broad sense of the term. But yes, so I believe we should be able to, the short point was, able to say at least what is manifestly unjust.
Understood.
By shades of grey in other matters, of justice or injustice, a matter of struggle, and we don't have monopoly on the meaning of any term. So we must listen to others. And listen to others, you say, you can't write an open letter to Chief Justice of India. Even if they do patently wrong thing. We did it. And we had 4 people in the world, and then 5 years of flogging. In the memorandum of regulatory reform, lobbying, writing, newspaper articles, asking, requesting others to contribute to it, which some did not. Some wrote against us. It's no function of law teachers to write a letter, open letter to Chief Justice. Fortunately, Chief Justice Chandrachud, the senior Chief Chandrachud, in a function at Indian Law Institute of Progressive Law Association, and journal was being released. And he asked at that time, sorry, the plug was not aligned. I suddenly saw it. I suddenly found, he said, he looked at the page of the journal and he said, where is the open letter here? And it was a big break for us because to Chief Justice of India saying uh, it was very critical of the court, but ultimately even he suggested in the last paragraph that the judgment sounds to us as patriarchal. It was that term, heavy term to use those days. Now it doesn't make, it's not that heavy. But in those days, and then the women's movement took on the cause, which is very good. But they asked us to sign a review petition. We said, we are not going to do that. Ours was a pedagogical effort. You don't ask for review, we just ask them to realize, if you look at the last paragraph, error of its own ways, to learn and reflect on the error of its own ways.
Yes.
We are not seeking a review. They were very badly misunderstood, but Latika and I refused to join the review petition. And of course, the review petition was then after dismissed. That's another matter. And later on, beloved Justice Krishna Iyer wrote a judgment only 6 months after the open letter or so. I forget the name of judgment, it's just now, but it's come back. He began his judgment by saying, sometimes an ounce of sensitivity is worth tons of reform. An ounce of judicial sensitivity is worth more than tons of law reform. Now, what more can you expect in a society which is deeply patriarchal than a Supreme Court judge saying this? And what more can you expect by way of endorsement for social change than this sentence? So we had our moments of time, but there were also moments of big letdown. And Bhopal case, for example, which I was very active in. And we were representing the victims. I was hypnotic at the time, but victims associations were a part. And the case was settled in the closed doors of the court.
Yeah.
By Attorney General Nepali Nariman and by the Justice Party. And a settlement were announced. And I went to town on this. I sought a review to the victims associations, saying, how can the Supreme Court go against the foundation of natural justice? We're a properly implemented party in a suit. And you decided by listening to two parties behind closed doors and settled our matter. We were never consulted as victims association. Now we are granted a post-decisional review with Justice Vice-Chancellor. His October order gave us a post-decisional hearing. A post-decisional hearing, of course, still the fate of the victims. But it kept the amount of settlement where it was. Our claim, Indian government claim, was $3 billion US. And they ordered a settlement of what? $450 million. You can see the difference. By that time, the politics of the day was consumed by Bhopal litigation scandal. There was nothing to do about the external atmosphere, political atmosphere. No one took the Bhopal disaster as seriously as an act of injustice. And long ago, I read a small book by teacher of John Rawls, Harvard, called Judith Clark. Judith Clark was a political scientist who taught John Rawls. John Rawls was in class. And she gave a set of lectures called a Toss lecture, a jail, in which the central question was the distinction between misfortune and injustice. The more you lean on the side of misfortune, the less pressing the justice question appears.
Understood, sir.
So not every disaster, if you recognize every disaster as a misfortune, then victims are left to bear their misfortune. Nothing you can do about it. Accidents will happen. They are normal accidents. Charles Perrow, a sociologist, wrote a long book called Normal Accidents. Accidents do happen. So not all accidents are unjust. Only some are unjust. And what are just a matter of struggle and what are just a matter of opinion, public opinion, general opinion. Anyway, so sorry, I went on and on.
No, sir, that actually really nicely unpacked the difference that I asked you, and thank you so much for weaving in the Mathura open letter and the Bhopal gas tragedy into
But I tried to be
the
more disciplined.
Sir, you sir, you argue in the V.V. Giri lecture, memorial lecture that Ambedkar's Articles 17, 23, and 24 are in fact labor rights of the highest constitutional order, and that somehow in this the Dalit labor movement is missing from the decent work conversation that ILO has recently started. So now, why has this erasure happened, and who do you think that such erasures benefit?
Oh, I think your question answers itself. The question of decent work raises. I always used to teach several decades ago, 35 years ago. I used to ask my class a question as to what is the distinction between um, justice and injustice. Can you describe systems of injustice? Can you describe systematic injustice, which inheres in the system? Now, varnashrama dharma is a dharma. It's a duty of certain varnas to discriminate against others. So, in a caste-bound society, the question of decent work only applies to the higher caste, who do not do obnoxious labor, not merely indecent, but obnoxious, like cleaning the night latrines. Dry latrines have come out that later on, or burning or attending to to the graveyards, or to attending to corpses, or hang a person. I was helping not Justice Professor Ishwar Desai in Surat. Now in Surat, he's running the Center for the Social Studies in Surat. I was doing in university. And there was a backward classes commission that he said, government set up, and the chairperson. I helped him. And we discovered we took a decision that we would not do backward class list. We do run a commission. That we would not do it by caste, higher and lower. We do it by occupation. So in the Gujarat report, our schedule consists of not caste, but occupations. And one of the occupations I discovered, and we included it in the schedule, hangman. They are not women, unfortunately or fortunately. It's always men, male of the species. It's difficult to feminize. You understand? So I don't feminize it. Hangman. Now, at that time, and even now, I think, what do they earn for hanging a person? It's a very messy job.
Yeah.
And there are castes of hangman, not person.
Yeah.
Somehow feminism stops there. So you can't say hang person, hangman. Um, they are paid at that time my studies showed. Nobody studies hangman. A decent work, we talk about in a caste system, nobody studies the indecent. People do the indecent work.
Yeah.
The hangman was paid 250 rupees plus TNDA for execution. TNDA, third class, that used to be third class fare, railway fare, and 250 rupees for hanging. And in fact, they were lower caste. Now, OBC will come into that, but I don't think they actually, when we read the list of occupations, some of them were not OBCs. They were not there at all. When you look at occupation and how they derive their income, you find a different picture altogether. But yes, so that's how social gradations occur. So somebody has to do the work, right? Now, decent work is supposed to be done by higher caste. Indecent, obnoxious work, cobbler. Even Mohandas Gandhi had to apologize in the height of freedom struggle to the Bombay Bar for saying lawyers are like cobblers. Mohandas Karamchand Gandhi wrote apology to the Bombay Bar. It's in the Young India pages. So in a caste society, indecent work is by definition reserved to lower caste. In a non-caste society, whether it's playing of animals, making shoes and chappals, cleaning latrines, anything that is obnoxious as defined by higher caste. No higher caste person will leather worker. I have a friend who was the Vice-Chancellor of JNU, Naiduma, Professor Naiduma. And Professor Naiduma was a scheduled caste person. And I befriended him, and a very nice man. And Naiduma said he did his PhD on leather workers, and he was specialist on drums. And it's not only merely shoes and other things that leather workers. Drums also made by leather workers. Tabla player, and musical instruments which require use of leather, bit of leather. But certainly drums require a lot of it. So it is, what indecent work is a very interesting question. What work is indecent? Can work ever be indecent? Can working for family and friends and making two ends meet be indecent? What about the dignity of labor? These questions are never asked,
Understood, sir.
never raised. So indecent work is something other people do. And because they're other people and they do it, I won't be concerned with that. That's
Understood.
the general approach.
Yeah. So, in the
Right.
same lecture, you call fair globalization an oxymoron. And so, I just wanted to ask you, what does fair globalization look like to you? And is it an impossible dream? Is it achievable to have to have fair globalization in this world? You would mention this in the same
Yeah,
lecture.
a long reply to it, but I won't give a long response to it. I would say um, certainly you can speak of a fair globalization, fair meaning just, reasonable.
Yeah.
But I've short, I had developed in Warwick when I was teaching there, G1, G2, G3. Globalization 1, globalization 2, and globalization 3. Um, Now, 1 is always occurring in history. That is by conquest. You occupy the people, territories, resources, extract them, do what you like with it. And that is colonial expropriation. The globalization 1 is hegemonic. Globalization G2, I've defined as process of diffusion. You learn from each other in terms of societal learning, civilizational learning. Globalization 2 is not imposed. G2 is voluntary. And it consists of traffic of ideas, learning things, unlearning things, like banking, insurance, maritime traffic, rules of the road. These are things we learn, and
Yeah.
they then become social technologies themselves. There is no earthly reason why you should drive on one side of the road or not on the other. But there are conventions. So some countries drive on the left side, most countries drive on the left side, but there are some which drive on the right side. So it is how social conventions develop. And it's very interesting to look at that, what we learn and what we unlearn from globalization. And there is another kind of globalization which stands for global humanism. And it's a short span in history, in modern history, when it appeared through a series of UN resolutions, hardly 10 years or 15 years of UN,
Okay.
in the 60s and 70s, due to the non-aligned nations movement. And a series of declarations happened. And one of the declarations was the Declaration on Social Progress. It's a beautiful document. The development is not enough. The development should be just, which we now call sustainable development. Much of the ideas flow from the declaration. There are a number of declarations in for just, fair, and prompt compensation on what they call common rights of humankind, declaration on national sovereignty over resources, a number of declarations. If you study the 60 to 70, the UN resolutions, you find global humanism emerging. So I think if you ask me what is fair globalization, it is possible to arrive at a working notion of fair globalization from this period of United Nations. That you can have a redistributive globalization as well as a globalization that favors wealth maximization on certain hands. That's also globalization. That is the globalization of corporations, hyper-globalization. In fact, Michel Foucault, in one of his books, marvelous set of phrases. what they call hyper profit and intra power. Intra power is capillary. It runs through your vein. Power is not outside. It injected inside your body and mind, implanted into your mind. So no question of justice ever arises in your mind. You consent to becoming subordinates, not a free agent. You are slaves to global capital, or slavery in a classical sense, or slave in patriarchal sense, or any other sense you take. You consent to a subordination. You don't question subordination. So it's a complex thing, but it's about there are different kinds of globalizations. It's essential to respond not to confuse matters. G1, G2, G3 are very distinct phases of globalization.
Understood.
And it's important to study them all.
Yeah.
But there's a difference between imposed globalization and voluntary globalization. Now, where I live in Delhi, I don't know about what happens in other parts of India. The place called Gurgaon, there are a lot of people, Indian people, are so fond of Korea. They call themselves Koreans, they learn Korean language, Korean customs, they watch Korean movies.
Yeah.
There's a process of cultural diffusion. I don't know whether it occurs in South also, I don't really know. But very often, either through sports or through movies or through pop cultural diffusion, you one has one acquires the identity which is transnational.
Understood, sir.
So it is globalization by consent, by civil society, which we don't look at. We may scholars studying globalization look at either imposed, but we don't look at voluntary globalization.
Yeah.
Every
Understood.
time yeah, I go to mall for lunch or for buying things, also everywhere, and shopping at malls. Now, I often say to people, I said, young people today are mullahs, M-A-L-L-E-R, mullahs. They're human beings. It's like, I don't think there are enough studies, sociological studies on malls. At whose expense, at whose right cost are malls built? Constantly air conditioned 24 by 7. Who
Understood, sir.
gets entry into malls? So you think globalization is, sorry, you were saying something?
No, sir. I was just saying that really puts things into perspective of how globalization could be voluntary and it could be imposed. And the problem only lies when it's imposed. And it is actually good if it is voluntary.
Yeah. Well, if you look at gig workers, for example,
Yeah.
civil society takes a large part, not the state. State does not command you. Take justifiable criticism of state and state powers, and we should continue to interrogate it, and they should be accountable. But likewise, civil society should be accountable too at the bar of justice and human rights. Now, gig workers is a classic, poignant case. We just order things and we want them on time. And we middle classes, upper middle classes, care nothing at all about the working conditions, about the inability to unionize, about the speed economy which they must operate. at their own cost and the cost of their families. We just don't know anything about it. Therefore, again, the caste system comes in decent and indecent work, many ways. So there is a problem in fact, at one time I was so cross and with people in a public lecture. I was heard to say I rarely get cross. I normally am sensitive to all sides of the opinion, which leaves me very little to say ultimately. But this time I was very upset. I said, we Indians don't have a civil society. What we have is an evil society, evil society. And the task is to come out of evil society and to make it a civil society.
Understood.
And what's a civil society? The fraternity of people. There's a fraternal solidarity, a spirit of solidarity with those who suffer. The task is not, we don't have a civil society. The task is to construct one. Now, maybe I was wrong. Maybe as a civil society, it's doing very well and flourishing. I'll be happy to be proved wrong. But sometimes I feel that this is somewhere right, at least from the point of view of justice, social justice. Think about it. I don't know the answer to everything, but I have questions.
Sir, you also wrote in the year 2007, Human Rights in a Post-Human World. And that was long before AI, and AI was a mainstream concept. But
Yeah.
apparently, all the fears or whatever you had written about is very true, and AI has become a mainstream concern. So, in your opinion, have the rights frameworks adapted according to the changing circumstances?
No, I think first of all we must thank you for putting this question. I'm working on it. I had a long time afterwards, after that, presaging it earlier. Mm, but as I studied, I'm very, very, very pessimistic. They know such thing as AI. They're a group of entrepreneurs who make a lot of money by selling certain things as AI. And they're primarily Silicon Valley chaps, but every country has its own Silicon Valley nowadays. So Hyderabad becomes Cyberabad or something like that. So we have all kinds of things happening everywhere. Uh, Basically, it is earning super profits. But as I study it, I say, first of all, where does AI come from? AI comes from military technology, and then it becomes civilian technology. Now, very few people have noticed it, asked the question about origins, and how far origins continue the original sin, as it were. Because in defense, what we call defense is ultimately annihilation of the other.
Makes sense.
Whether you stop water, whether you kill them, whether you. It's a military must kill. To be killing on both sides to an enemy, and there's something called enemy. So militarization is a field in itself in which there is not antagonism, but war. If we in civil society have antagonism, our interests are to each other, we fight each other, we don't kill each other. The military technology, you must kill in order to achieve a victory, annihilate in order to have victory. There's no other way. So it is, first of all, we have realized that it's come from, it's embalmed in military technology. And how far of that, if you look at drones, drones can be used in marriages and to throw flowers below people. There are parties in Delhi, I don't go there, but they attend once when drone came and showered flowers over us. Now, marriages, drones are used for delivering things high speed. They are civilian uses. But essentially, religion is military, and we must bear in mind. Secondly, um, AI is just a bunch of billionaires. People who do business. They don't. The AI is the AI programs which sell, the hard sell. And the main problem there is posed by consent. And the consent disappears. The vanishing consent. You have to sign the click of a mouse. You have to agree to the condition. You don't agree, you're not given access. There's a series of programs. Now, there's a favorite thinker of mine called Ray Kurzweil. And Ray Kurzweil has made a number of professors, computer scientists. Ray Kurzweil calls it, he is concerned with superintelligence. And AI is superintelligence on the way. And he calls it singularity. He doesn't call it superintelligence, he calls it singularity. In 2004, Ray Kurzweil wrote a book, it's very good, big fat book, called Singularity, Singularity is Near. In 2024, he wrote a equally fat book called Singularity is Nearer. Not millennia, but closer. In which he predicts, and rarely, as I said, his predictions are wrong, but in which he predicts, and I won't be alive then, but you will be. If there is metaphysical communication, please talk with me. Then, but he is rarely wrong in his predictions. It's by 2047. Non-biological intelligence will overrule biological intelligence. This is called singularity. 2047.
So, do you
Where
believe
the
in
brain will become, pardon me?
I'm saying, do you believe that non-biological intelligence will overrule biological intelligence into 2147?
Superintelligence, that work of AI, and already we have arrived in partly by what is called the AI circle as agentic AI. Already we are getting there.
Yeah.
So we are getting there. 2047 is a definite date where the human brain will be replaced by silicon brain. And the computer programs will write themselves. There will be no need for algorithms.
Yeah.
That's the ultimate in superintelligence. The vanishing of the human brain. As I said, I won't be there, but you kindly communicate with me. You find a way. You would have found a way. In superintelligence will find a way. Where I am, if I am. So that's interesting, and that is going to happen. That is every sign of that is happening. But my views on AI are that there should be a moratorium. I've been urging that. I've been signed internationally, many urging moratorium on AI program. Because why it has its upsides, like the speed at which we all used to search functions and find useful, and chat boxes which I don't use, but people say chat box is very good. So I know of chat box hallucination and all that. I think The downside is to be thought about very carefully.
Understood.
One is in terms of famine and freshwater supply. The data centers consume a large amount of fresh water, which is never to be replenished on the face of the earth
Yes.
and used as a coolant. Also, they drain a large amount of fresh water. They also drain a lot of power. So data centers that are necessary and they have to build in every state in India and every part of the world pose enormous threats in the future to electricity and power and to water. And there have been statements from Microsoft and other one about corporate sustainability, but they have to be taken with mountains of salt, not pinches of salt. So this is one thing. And there are other flip sides to that. I've written not excessively, but quite a bit on this. A freshwater power, the land we are there sitting on, and the heat energy they emit has its own cost. So social cost of AI versus social benefits of AI have not been thought through.
Understood.
And that's why I joined the pleas for a moratorium. The AI at the moment is not general intelligence. It is a bunch of youngsters in Silicon Valley and outside who have become entrepreneurs and sell their wares program. And I've gone through the statistics, I don't remember now, how much fresh water is consumed by a single checkbox operation. It's very, very high. So in times to come,
Understood.
these industries are power intensive and water intensive. So they lead to greater amount of desertification and all kinds of surrounding problems. So we must study costs and benefits of AI rather than having just a craze which supports fill the billions that to various programs. And I urge you and anybody who listens to this discussion with us to sign a pledge or a moratorium that programs should stop coming in the market till we get a sense of cost and benefits of the AI process at work,
Understood, sir.
social cost and benefits. In terms of rights and justice cost of as a standard nowadays, standard environment assessment, environment law. Under human rights law, there's a standard requirement of human rights cost assessment, impact assessment. So why should there not be a regular assessment and an audit of total cost of AI?
Yeah.
I mean, it's a standard thing. It's a template. You can look for it and you can redo them depending on needs of industry. The AI as it exists is the private companies totally unaccountable to society.
Makes sense, sir.
Maybe they hire learned professionals, that's a different matter, but they are also unaccountable as much as they are learned to society at large. And so some device has to be found. They yet been found, not yet been found, to regulate industry. Well, I should qualify. Sorry, you asked your question. Do you have a question
Yes,
or
sir.
a comment? Tell me.
No, sir, I'm listening.
I said, but long time back I did a book which is very interesting. When digital empires collide. It was done in 2013 by a person, I forget the name. Um, oh God, very important book. Um, she said she studied China, America, and EU. Uh, the authoritarian pattern of regulation of AI is to be found in China. The laissez-faire is to be found in America. And the human rights standard approach is to be found in EU. Now, EU is therefore lagging behind in the race for AI. That's it establishes. And she establishes that the, the current race between for AI between China and USA.
Understood.
And it's a very interesting book. I tell you the name of the author, the my
Yes.
2000 book, 2013 book. I send you an email, man, with the name of the author. She is wonderful. And she studied this regulation of AI in each of the blocks and why the authoritarian model is likely to prevail. So we are not talking merely of AI programs. We are talking of social programs of governance. And you cannot forget Israel when you talk about AI
Yeah.
or Ukraine.
Yeah.
These are, in terms of drones, Ukraine, in terms of drone technology, is way ahead of others.
Yeah.
And AI is used there. So we can't forget any country in studying this, but I think we should, comparison has begun among these three blocks. The authoritarian AI, the laissez-faire AI, and human rights AI. And therefore, the, a lot of discussion take place on cyber rights and cyber surveillance. That's okay, it's in its place. But the state of Israel is unique. For example, Pegasus
Yeah.
program that was put on the cell phone without the consent of the owner. The stealth technologies, where no consent is taken, but surveillance is established. Maybe this conversation is going somewhere between you and me. We think we are talking, and Riverside is calling us. But we live in a data society. Everything is public, even without our knowledge and consent.
That's true.
Public in the sense that benefits a particular group of people who are in industry. In the bot land.
Yeah.
Bot land, bots. Land populated by bots.
Yeah.
Human beings don't matter. They're all bots. We're all commodities in the free market of competitive market of AI venture capitalists. They're no longer human beings exist. They're all data.
Understood.
Data producing, data emitting, data consuming
Yeah.
people. People, nobody not people. We are bots. Sorry about this. Yeah. And therefore, we should not talk about human rights. We're talking about rights of bots.
No, that's a really nice way to.
Yeah. In fact, I had proposed long time ago. I said we should not talk of human rights, but viewer rights.
Yes, sir. That was very
Eh,
interesting that you had written this piece in 2007, and a lot of it is looking exactly. It has become a mainstream concern, and We are awaiting. You said you were working on writing the next part of it, and we are really awaiting, looking at
I
what.
must read my own book. I must read my own book. Yes, I get invitations because I'm supposed to have thought about all this earlier.
Yeah,
But I've look at it carefully again because I don't recall what I had said. I'm at an age where I forget what I had wrote myself. But yes, I must have. I recently got invited on
yeah,
the strength of that book.
yeah.
And then I was reminded of what I had said there. I said, my God, dear, this is so I
Sure.
must look at that again.
Yeah,
But that's neither here nor there. That's neither here nor there. A book has a life of its own, and that's the essential idea.
yeah.
Um, so I'm glad you have read all this stuff, and other things are more important than law, isn't it? Law and other things, law and other things. Other things are more important than law.
Thank you so
For
much for
example,
that well said.
so,
That's an amazing way to end our podcast, sir. I'm so glad you gave us the time to come and speak to us.
I'm very glad we could talk.